I want to put a pin in a lot of what you just said, because that's going to come up as we start to discuss in the Dobbs case, which, effectively overrules Roe versus Wade. You know, what you're talking about in a lot of ways is what's called originalism, which is it's a doctrine of jurisprudence, and it's I'm sorry, but it's honestly a little embarrassing as a lawyer to have to talk about this like it's a serious thing, but it is a serious thing. Like, there are 6 members of our Supreme Court who subscribe to this thing, and people who get their law degrees from Yale and Harvard who think that this is a thing. It's on its face very stupid. And what it is originalism is the idea that when we're interpreting the Constitution as judges, we must look to the original intent of the drafters, and we must only interpret those rights to mean whatever they must have meant at the time those words were put on the paper. So that necessarily excludes any rights for non-white persons, women, and frankly, any white people who don't happen to own land. And so it's absurd, it's vacuous, it's silly, and like I said, just embarrassing that that's something we have to take seriously. But that is the predominating judicial doctrine on today's Supreme Court.
Do you want to get into what the Dobbs case is actually about?
Good call. Let's talk about that. But I think, a little background on Roe is probably helpful, because right, the Constitution obviously doesn't specifically say you have a right to get an abortion. So how did the court arrive at a fundamental right? And so to get there, we have to look at the due process clause. There's 2 of them in the Constitution. There's one, the 5th Amendment, one, the 14th Amendment. Not going to get into the weeds too much, but basically, courts have taken the view that there is something called substantive due process, which is the idea that the Bill of Rights and the Constitution generally protect more rights than just those that are specifically listed. That, due process was meant to encompass a whole bunch of other things. And so then it's a question of, well, what exactly are those? And some of the things that we found are, for example, the right to control your children's education. And that's been baked into our law since 1925. There was a case called Pierce that basically struck down laws that required parents to send their kids to public school. The right to use contraception is something that's been upheld by the Supreme Court as a fundamental right, something that's covered under substantive due process. Interracial marriage, the famous Loving versus Virginia case, 1967. Consensual homosexual sexual acts. That was a case called Lawrence versus Texas, 2003. And then more recently, same-sex marriage in the Obergefell decision that came out in 2015, ruled to be a fundamental right, a right to marry a person of your choosing. Now, there's a dark side of this doctrine, and we may be approaching that as well again, where we had a period in U.S. history called the Lochner era. It started right after the Civil War and ended in 1937-ish, where basically the Supreme Court said, there is substantive due process, and the most important right under the Constitution is the right to enter into contracts. And it's so important that people be able to enter into contracts that it basically trumps everything else, including minimum wage laws for women. Hey, if women want to enter into agreements with their employers to work for pennies, they should be allowed to do so. So you can't have those. Prohibiting union busting. Hey, these employees signed up to take this job at these rates. There's no reason we should be able to stop employers from tamping down unions. So the Lochner era was kind of a dark era of using substantive due process to beat down rights in the name of upholding corporate rights, effectively, right to contract. And that kind of dovetails on what we were talking about earlier, that all these concepts have a shadow side, and you can flip them, which is why this idea that there's some objective right answer, there's some that these judges are just sort of divining from outer space the correct answer, is foolish. It's always a political and a policy choice. So let's talk about the decision in Dobbs, which is the name of this case, right? So that's how we get to abortion as a fundamental right, is through basically the right to privacy under substantive due process. That's been the case for 50 years. It was upheld a couple times, most notably in Planned Parenthood versus Casey. The Supreme Court slightly changed the guidelines. Originally, they said states can't prohibit abortion during the first trimester, but eventually they said, well, the trimester thing is unworkable. We're going to have this new standard that's viability. So you've probably heard that, right? So you can't prohibit abortion pre-viability. So that became the new standard. But in any event, the law's been upheld. When Brett Kavanaugh sat before the Senate in his confirmation hearings. He said,
Mhm.
this is settled law. It's been upheld multiple times. It's settled, right?
Mhm.
Well, we all knew that he was lying. We knew
Yeah.
Susan Collins was lying. We knew everyone was lying, and they got away with it. So now we have the Dobbs decision, and this leans on originalism, which we talked about. This is Alito saying, well, look, the only rights that the Constitution upholds are those that were contemplated at the time it was written, and that are deeply rooted, this is the exact quote, deeply rooted in this nation's history and tradition. Now, how deeply rooted in the nation's history and tradition are the rights of colored persons,
Mhm.
women, LGBTQ people? So if the decision is obviously horrific on its face in terms
Yeah.
of what it's going to do for abortion rights, and we can talk about what the immediate impact is going to be.
Mhm.
But what I want people also focusing on, because I know that there are probably, there may be people listening who are never planning to have kids, and maybe this is like, whatever. Well, I don't think anyone's whatever about it, but I think people are like, well, maybe this won't affect me personally.
Yeah.
Or people, or men listening, frankly, because I think there can be a
Yeah.
collective sigh of relief from the dudes among us who are like, whew, well, I'm glad I don't have a uterus. Wow, that'd be a drag.
Yeah.
Well, this could mean things for your rights too, because
Yeah.
if we're going to usher in a new era of originalism and only upholding constitutional rights that are specifically enumerated in the Constitution and that are rooted in the nation's history and tradition, whatever the F that means,
Right. Yeah.
a lot of rights are going to go away.
Mhm.
A lot of rights are in danger. We could see prohibitions on interracial marriage. Certainly, we will, and I unfortunately predict we probably will see same-sex marriage go away,
Yeah.
at least at the federal level. And thing is, it also opens the door to prohibiting those things at the federal level. And that's something I don't see people talking about right now. It says, this goes back to the states. States can criminalize it if they want, or they can allow it if they want. That's what we have right now, right? But Republicans could take back Congress in 2022. They could take back
Mhm.
the White House in 2024. And under this decision, there is nothing to prevent the federal government from banning abortion completely.
Yeah.
Absolutely nothing, right? And how do you roll that back? Or for banning same-sex marriage. So then there won't even be a safe place to run to. Like you can't hide out in California or New York and go, well, at least we still got the right out here. You may not. So we've all got
Yeah.
to fight. Like, even if you're feeling like, you're not directly impacted by this right now, or you're in a safe blue state and you still have these rights for now, like, don't bank on that. All right. That may not
Mhm.
last. It's kind of the worst version of this decision, really, that we could have gotten. I mean, there were lots of ways that the Supreme Court could have curtailed the abortion right or restricted it further, or even upended Roe without opening the door to all these other horrors. And there's language in the opinion that kind of sets the stage for protecting fetuses as persons under the US
Yeah.
Constitution. I mean, think about what the implications of that are. So
Mhm.
it's pretty troubling.